Number 157 on the calendar, People versus Roy Kangas.
May it please the Court, I'm Mark Curley. I'm here for Appellant Roy Kangas, and I'd like to reserve 2 minutes
2 minutes, sir.
for rebuttal. Thank you. Your Honors, this case presented competing claims or sponsorship and certification of some business records. There were 2 separate exhibits. One was from the New York Forensic Investigation Center, Simulator Solutions, and one was for calibration and maintenance records, and that was from the Division of Criminal Justice Services.
Can we ignore the ones from the county and just go based, if there's an appropriate certification based on the state agencies, then why isn't that okay?
Well, it depends on how they're put into evidence, Judge. They were put in under 4518A and not 4518C. And I would say that there's no discussion of certification. The proper analysis for a business record is 4518A generally, and that requires an analysis of are they made in the regular course of business by someone who has a duty in a close temporal proximity, et cetera. And then you get to the second part of that paragraph that says, is it an electronic record? And if it's an electronic record, then you have to go to state technology law 306. 306 will direct you to CPLR 4539 to ask whether it's a reproduction or not. Certification only comes in under 4518C, which are records that are produced in response to a subpoena. And there's a good reason for that. A subpoena catches someone's attention. It's too easy for a certification to be a robo-certification. And this case is a good example of that. The sheriff's office may have thought that those were business records of their own, and they certified them.
But I'm saying if we ignore what the sheriff's office did and we just look at what the state did.
If you ignore it, then the certification has to be made under 4518C, and those have to be subpoenaed records. 4518C says they're either 2306.
Is that because you say that 4518A doesn't apply or doesn't apply to the government?
4518A doesn't mention certification at all. I would say that certification is not enough under 4518A. And I would suggest to you, Judge, that no, I heard the first case here talk about decisions that were 150 years old, and I'll say to you that when electronic technology is involved, 10 years is 150 years.
So what should have been submitted?
I
What
think
would have been appropriate in this case?
To subpoena the records in from either the Forensic Investigation Center or from the Division of Criminal Justice Services. When they're subpoenaed in, whoever is signing in response to that subpoena is alerted to the gravity of the request, and they know that they could be pulled into court to answer it. If not, you're going to get subpoenas, or let me use the certification that they provided. It says, these records are made and kept by us, and they're properly protected.
Now, you're talking about the Ontario County Sheriff's Department first? So you're talking about, no, that's not Limoges, that's Felshaw, right?
Pardon me?
The Ontario County Sheriff's Department is Felshaw, right?
Yes, that's Katie Felshaw.
All right, so let's, I think, if I understood correctly what Judge Stein was saying, let's assume that her certification to comply with the business records exception was wrong because they were not records that were kept in the ordinary course of business by the Sheriff's Department. There may have been a way for her to certify them, but the way she certified them doesn't meet the requirement of 4518A. All right?
Okay.
All right. So assuming that. So then we have Exhibit 7 and Exhibit 8. Now, one was preserved and one wasn't. But in my mind anyway. But leaving that aside, does county court, as I understand it, concluded that 4539 doesn't apply to documents that are originally created in electronic form. And here we're talking about the electronic stimulator solution record, which is what was contained in Exhibit 7. We got the data calibrations 8, simulator solution 7, right?
Yes.
So county says that it wasn't, county court seems to say, and they make a good argument, that those records were originally created in electronic form, and this is where 4539, I suppose we need to talk about that, comes into play, because 4539 really we're talking about PDF-type context
Yes.
documents.
Yes.
And so it wasn't created electronically, so therefore it doesn't apply.
Well, Your Honor, the county court concluded that all the records that were submitted were originally created in electronic form and were never in any sort of hard copy. But that's not true. The certification from DCJS by John Digman says these are photocopies. There's no way to photocopy a purely electronic record.
And there's no electronic signature. He has an
He
actual...
actually signed it, yes.
But was the copy that was received in evidence, did that have his original
No,
signature on it?
there was no original
How do
document
we know that?
because they came out of the prosecutor's briefcase. They're faxes. They're not, there's no pen and ink involved.
Well, it's funny when you look at them. Digman's signature on one looks like a photocopy, but then another one that looks like maybe Limoges, looks like electronically created signature.
does.
Is that fair to say?
Yes.
Yeah, okay.
Yes.
All right.
But there's no way to challenge any of that at trial. And that's, if you look at the testimony of Sean McVicker, who was just the poor breath test operator, you know, John Leonard asked him, have you ever seen these records before? He says, no. You know anything about them? Do you know if they're kept in the ordinary course of business? And he says, no, I don't know anything about that. So there's a problem with a certification being conclusory, with a certification saying these records are protected. These records are not subject to tampering or degradation. Or even these records are business records. Who knows that? So I would submit that there was no proper analysis in this trial of whether they were business records, and certainly no analysis of whether they were electronic records, how they should be protected, even if they should be accepted, and their admission was error.
How does 4540 come into play here?
4540, Your Honor, comes into play with public records, okay? And these are not public records. I have a hard time even getting these records. So I would say that public records are a product. They're not something that's kept in the ordinary course of business. And I'll use the analogy, if I publish a newspaper, the actual newspaper is not a business record. Okay? It's what I'm publishing. It's my publication. But my business records as a newspaper publisher are my invoices and my checks and my bills. So there is a separate section for public documents. I don't think it has no application here.
Where does it say public documents? It says, as I look at 4540, it talks about an official record. An official record, not a public document.
Well, it says copies permitted in official publication, and that's what I meant to say.
Thank you, counsel. Counsel?
Good afternoon. May it please the court, I'm Steve Cox for the people. Two exhibits. First, I'll touch on the easiest. As Judge Fahey mentioned, the Exhibit 7 is a digitally created and digitally recorded exhibit. That's where we're going from now on. That's pretty much how all exhibits in these DWI trials will be. There aren't any more handwritten and signed exhibits. It means that it never existed on paper. The analyst makes the report on computer as he or she is completing the work, and has a process that's involves a number of steps to secure the work once it's completed.
How can Felshaw certify it as a business record? How is she authorized to do that?
That's the first question, is whether that would go back to, if that argument is feasible, that could only happen under this court's decision, Kratzley and some of its progeny, that the Sheriff's Department...
Is there any evidence to support a Kratzley analysis here?
I believe so. I mean, the Sheriff's Department gathered these records from the state for purposes of ensuring that their data machine operated properly. They kept all these records, and what happened is, rather than give an original to the ADA, they formed the policy of certifying a copy of the original they had to give to the ADA.
But we don't know if they shared procedures or anything like that.
I'm sorry?
Doesn't Craftsly say that they have to have shared procedures or adopted?
Not shared procedures, but what they called circumstantial familiarity with the documents. In other words, if the Sheriff's Department, as entity B, is so familiar with and relies regularly upon the records of DCJS or the state police in the course of their business of maintaining the data master instrument, be sure that it's operating properly, then they can reasonably rely upon those records and create their own records of them.
Who keeps the original?
I'm sorry?
Who keeps the original? What they are referring to as an original? Who's got
What
that?
Katie Felshaw referred to as an original, she kept. She has on file,
And what
and
is
she made a copy and
what-
certified it.
Okay, you say what she referred to. What is the original she's referring to?
It would have been the original copy she'd received from
So it's a
Jennifer
copy.
Limgoss and John Digman.
So it's a copy.
Well, no, it's an
Saying an
original.
original
She
copy?
received an original from the state.
That's what I'm
She
asking.
keeps that and makes a copy of it with a
Okay.
certification.
So then even though Jennifer, I'm not sure how it's pronounced,
I'd say it's Limgoss.
Limgos?
Yeah.
Thank you, says that she has in her possession the original, that she's turned over the original, is it?
There are
Am I reading
two,
the
that's
wrong
the
thing?
difference, there are a secondary certification. What happened here, and the reason I don't rely on the Craftsly argument as much, is I think the trial court, if you read the transcript, effectively said, I'm disregarding Katie Felshaw's certification, because don't you have the state certification?
You're talking about city court said that in the record. They
Yes.
apparently did, of course, which preserves the argument also.
Yes, so I think the
Challenge it.
county
I'm
court
but
said
again,
city court was
it's just
okay
a
doing it.
straightforward question. Who has the original?
Exhibit 1, the one I'm talking about right now, Jennifer
Exhibit
Limgos,
7?
is a digital document.
Okay.
So in a Zen kind of world, the original is on a hard drive in Albany.
On the hard drive.
Okay? When you print
Got it.
one, it becomes an original
copy.
under the State Electronic Records Act.
Okay.
Jennifer Limgoss had one, and normally we have one. Whoever prints one has an original. That's the concept under the Electronic Records Act. They're all, to me, they're copies, but under the Act, every time you create one, it's an original.
Who can you cross-examine as to the accuracy of it?
They're self-authenticating documents, so they're under 4518C, so long as you meet the requirements of that certification, they're admissible as prima facie evidence of the matter asserted in them.
I'm not suggesting that this happens, but there are mistakes sometimes, and if there's a mistake, no one's going to know it, right?
Mistake as to the that's a difference. Under a business record under 4518A, you'd have to have a keeper of the record,
Right.
for instance, offer that in. Now, that keeper of the record, you could cross-examine them as to, you sure you kept this record? But they
Right,
wouldn't know
quite
about
often these days,
the
they just say-
underlying matter.
I'm sorry?
They wouldn't know about the underlying matter. Defense
That's the po-
counsel in a DWI trial is always free to subpoena the chemist if they want to cross-examine the chemist about the process they use to test
Well, I always
chemicals.
think who's got the burden of proof, but it's, the only reason I ask is that we get pretty loose sometimes, and if there's an inaccurate reading, but we say, well, it's electronic, so you can't cross-examine, it's too bad, it's inaccurate, tough, and that's not what we want to say. We want to say, somebody can say, why do we believe that this is true?
Well, because that's exactly what they are, is calibration records. The requirement for entering, the people have to show the instruments in proper working order, right, under MERTS. And you do this in these DWI trials by, we take the most recent calibration record before and after arrest, certified copies of them, so that you've got probative evidence that if it was working before arrest and after arrest, it was working at the time of arrest, as well as the simulator solution record, because they have to use the simulator solution record to get a plus or minus 1.01 result after they conduct the test. All
Your
these things.
adversary says that these were admitted under subdivision A, 4518A, not C.
I don't
Do you
think so.
agree with that?
No, I think the trial court clearly recognized those 4518C. In fact, I think they said it met all the requirements of 4518C and admitting them into evidence.
And do you-
Because it admitted it without a keeper of the record. It admitted it as a self-authenticating document.
Do you also agree that Mr. Digman's signature was not an original on the exhibit?
I disagree that an original signature is required.
But you agree that his wasn't an original?
On the document that was, well, first of all, you have the exhibits, so you feel free to examine them.
Well,
The
we have copies
signature-
of the exhibit. Well, we do have the originals here, and I actually looked at the originals, and
Now-
they looked to me like copied signatures, but I just wanted to confirm.
Right.
if-
But that's, the question it poses to the court is, in today's technology, it's awful hard to tell the difference between a copy and an original sometimes. Before I did appeals, I did counterfeit cases, and, you can make money look pretty good, so you can make signatures look pretty good. I don't find in the law where 4518C requires an original signature. It requires a signature, a notarization, part of your certification requirement, and it requires an attestation. Those three prongs from Kennedy that say, you keep this in normal course of business and so on. All that is present here. It's
Counsel,
just a copy. It's not an original. But I don't think that
This isn't a
matters.
confrontation clause case, right? I mean, there's really no question of crossing the witness here. I mean, it's not confrontation, it's civil
No,
procedure, right?
no, it's not a confrontation,
So
no,
why can't
because
we-
it's self-authenticated.
Why, and this is aspirational, why can't we just say this goes to weight?
Once it's admitted, certainly it does. That's why I say, once the court received that exhibit, defense counsel was free to introduce evidence to try to diminish the weight of it. It's free to question the fact that it's a copy in front of the jury. But all I'm saying is that it was properly received and admitted by the court because from all I can find, it had a signature, it had a notarization, it had the proper attestation to make it a 4518C certification attached to it. And so long as the court was okay with ignoring ignoring the sheriff's department's certification and just saying, hey, I've got the same state certification I always have here, then it was it accepted it properly.
Thank you, counsel.
Thank you.
Mr. Curley?
Yes. Judge Stein, you have an original, according to Mr. Cox. He just told you that any copy that's made becomes an original as soon as you take possession of it, which loses sight of
Well, if
all-
it was originally electronically created, I think that was his argument. But a separate question was whether you need an original of a signature on a certification of a hard copy document.
Well, you need it for 4518C. 4518C says other records. It references 2306, which is only treatment records, medical treatment records, and 2307, which references books, papers, and other things of a department or agency. 2307 merely excuses the personal appearance of the witness that the proponent's going to put on to put the evidence in. So I think the subpoena aspect of 4518C, again, is important because it's an additional guarantee that we need. Otherwise, anybody can come in and certify that, make the decision for the judge. This is a good business record.
So you're
This
saying
is-
a certification signed pursuant to a subpoena, it carries more weight than a certification signed
Yes.
under
I don't know if it's
sworn-
fine, but it's much better.
Makes a difference?
Yes. And also, I would just like to say that there's no record of this anywhere in the trial record. So
When you
any
say this,
analysis
what do you
we-
mean? No record of what?
Of any analysis that we've just gone through, of anybody asking a question, how do I know this is a good business record? The witness they put on, he said, I've never seen it before today, and that can't be enough. Can I say one more thing?
Yes, sir, please.
As a practical matter, in city court, if I try and subpoena in any of these technicians, any of these chemists, technicians, the state police will be there in a minute. In county court, Supreme Court, with a motion to quash, they'll come in and argue that we can't bring these technicians down for every DWI court trial in a city court, and I'll be out the door.
Thank you, Mr. Cox.